good afternoon, everyone. On behalf of the IFA India branch, I'm pleased to be hosting this important webinar series. As most of you know who participated, that this webinar series has been spread over 2 weeks with 2 sessions each. We are on the second week and on the first session. We've had some overwhelming response for our webinar series, and my IFA secretariat just told me that we've had over 400 international participants from 23 countries. Wow, I never realized that we would be competing with a IFA Congress when we planned this entire webinar series. Well, the webinar series is all largely thanks to the Global IFA organization as well, because we've had some overwhelming support from there, starting with the chair of the PSC and many great speakers. Today we have another interesting lineup of speakers with us. And before I introduce the speakers, let me just briefly talk about what we are going to debate. And I'm personally looking forward to listening to our speakers on the important topic of domestic law meanings, including deeming fictions of undefined treaty terms. Now, this complex definition or description of the topic has been given by Dr. Dhruv Sanghvi, and he's going to tell us why it is. Because when we were first planning this session, my simple proposition to him was, why can't we keep it simple and just say deeming fictions under the domestic law and its fiction with treaties? He vehemently disagreed with me, so he will prove why this is a more appropriate topic. Well, on a more serious note, tax treaties, as we all know, which are an outcome of bilateral negotiations, carry basic concepts on what is business, what is profits, what is alienation, what is employment. And some of these are either, there is a definition or interpretation tools that are available under the international public law, but largely they get interpreted by the jurisdictions. But if you look at the domestic law of any country, there are many of these definitions which are there in the domestic law. So to harmonize all definitional aspects from a treaty standpoint, even if a particular state would want to do it, it's nearly an impossible task. And therefore, the magical Article 3.2 of the OECD Model Convention clearly provides that terms that are not defined in the treaty, unless the context requires otherwise, shall have the same meaning as it would have in the domestic law of the contracting state that's applying the treaty. Now, interestingly, the term, unless the context otherwise applies, has been subjected to enormous views and interpretation. And I don't recall which IFA Congress it was, but I do know that this was a scientific topic in one of the IFA Congresses. Further, the reference to domestic law is not static, because the domestic law keeps on getting amended. Rather, the reference in the domestic law meanings of undefined terms, as we call it in this topic, as they are at the time when the treaty falls to be applied. This raises several issues. It raises inevitable conflicts on characterization of income. It raises issue whether a state can amend the domestic law definition so as to alter the outcome of the treaty. Now, this is a very sensitive issue, because this is where the debate we get into, whether you're supposed to interpret the treaty with a static mindset or a dynamic and a moving mindset. When would these changes be tantamount to a treaty override situations? And when does the context require a meaning otherwise than the one that the term has in domestic law? We have a great panel today, Professor Dr. Stefan Wiegel. He is a very senior tax practitioner. More importantly, he was the chair of the PSC when I was a member. Dr. Dhruv Sanghvi, Vanessa Aruda Ferreira. Vanessa has done her PhD. She just disclosed to us that she has to defend her PhD on this topic, which is also called treaty dodging. Ajay Vora, senior advocate. Before we get on to the topic, just very briefly, some very basic announcements. everyone on the call is on a see only and listen only mode. So if you have any questions, you may want to raise it and share it with the moderator and all the panelists through the Q&A tab that is on your WebEx platform. Only the question raised through the Q&A section will have to be considered because you are not audible to us. And once this session ends, we request you that you kindly give us and share your feedback as well. There's a whole lot of technical material which we have put it out to support this topic, because the whole notion is that most of our academic institutions that are participating and supporting this conference have students of international law. So these reading materials are useful, but I promise you that these reading materials are so well researched that even if you are a serious practitioner, you kindly have a look at them. So with those words, I hand it over to Professor Dr. Steph van Wiegel. Over to you, Steph.
Thank you very much, Mukesh. Welcome, everyone. It's truly a privilege, as I have always felt enormous friendship towards my friends at the Indian IFA branch. And it even got better, Mukesh, because I understand we're not just doing this virtually with the India IFA branch, but with many other countries. So it's fantastic to be amongst so many IFA friends. It's also great to be in this panel. I should say that Vanessa and I have spoken about this theme quite a bit over the last few years, as I am her PhD supervisor, and she has been focusing on treaty dodging, in which Article 3, Paragraph 2, as she will explore, plays a significant role. And she just finished her manuscript. It was approved by the doctoral committee, and hopefully, COVID-19 permitting, she will defend the thesis before too long. And in fact, I can claim a part in Dhruv's fame as well as the co-supervisor of his thesis a few years ago. So actually, I forgot how many years ago. Many years ago, I guess I was also your master's thesis supervisor when you studied in Leiden. So many connections go through this panel. The theme is probably one of the underrated themes in tax treaty interpretation. There is lots of doctrine on many elements of the model convention, whether it be the permanent establishment, Article 7, treaty abuse, what have you. And even though Article 3, Paragraph 2 has received attention and significant attention, there is really so much to explore, and we gave a try in this panel along a number of slides that the panel members kindly prepared. And I wonder, Dhruv, are you able to operate the slides and move to the first slides? Yes, thanks. Let's stick here for a moment. So we'll start by talking about the place of Article 3, Paragraph 2 in the treaty construct and in treaty interpretation, and then address a number of cases in which various themes come to the fore. So it's the Melford case that my eye happens to catch is about static versus dynamic. There is the question whether, even if you have a meaning under domestic law, whether domestic law fictions filter through in the treaty application, and so on and so on. So we will present a number of cases, important cases that gave more depth to Article 3, Paragraph 2, and sort of show us the enormous scope of discussion in 3, Paragraph 2. Dhruv, next slide, please. Yes. Maybe if you go to the next slide, please. And next slide. Yeah. And then after this, we'll go back to the previous slide. So this is the key of our focus today in this virtual meeting. So I'll read paragraph 2. As regards the application of the convention at any time by a contracting state, any term not defined therein shall, unless the context otherwise requires, or the competent authorities agree to a different meaning pursuant to the provisions of Article 25, a phrase that was added in the 2017 Model Convention, have the meaning that it has at that time under the laws of that state for the purposes of the taxes to which the convention applies, any meaning under the applicable tax laws of that state prevailing over a meaning given to the term under other laws of that state. Now, ignore this slide for a moment and picture for yourself a bilateral tax convention, and you'll realize that there are many terms in this convention that are interpreted through different avenues. So there are terms that are defined in the treaty, and some of those we use a whole article of the treaty for. So the permanent establishment in Article 5, as part of another article, the definition of the term dividend in Article 10, and so on and so on. You'll find that some of the definition is left open. So even a defined term in Article 5 or in Article 10, you will find elements of the definition permanent establishment. You'll find elements of the definition of dividend that are not defined in the article itself. And then there are, of course, in the treaty, generally many terms that have not been defined in the treaty itself. And then we go back to Article 3, Paragraph 1 and 3, Paragraph 2. And 3.1 gives us a number of defined terms. And 3.2 will then address what we just saw, the situation where a term is not at all defined in the treaty. Both in 3.1 and in 3.2, there is this proviso that in 3.1 you use the meaning enunciated in 3.1. In 3.2 you use the meaning under the domestic law, under the conditions prescribed in 3.2. But both Article 3.1 and 3.2 have this important proviso, unless the context otherwise requires. Requires. It doesn't say unless the context otherwise allows. No, the context otherwise requires. So that's in a narrow sense the framework of Article 3 and the treaty interpretation. Of course, and that's why we have the slide here with the reference to Articles 31 to 33 of the Vienna Convention. We are also within the boundaries, the treaty interpretation boundaries of the Vienna Convention that prescribe the textual and contextual interpretation. Contextual in a different meaning shows us the supplementary means and the multilingual treaties that I think Dhruv will pay attention to in one of the cases he will address. Let's see. Maybe to give a bit of color, and then I'll hand over to Dhruv. The issue is with Article 3, Paragraph 2. The issues are manifold, and Mukesh already alluded to this. So there is the issue of static versus dynamic interpretation. In other words, would one, maybe, Dhruv, could we go to the language, the text of Article 3, Paragraph 2, please? Sorry, one back? Yes. To the fourth line from the bottom have the meaning it has at that time under the laws of that state for the purposes of the taxes to which the convention applies. So there is the question, or there was in the past the question, does one use the meaning of the term in the domestic law at the time the treaty was concluded or at the time the treaty is applied? And Dhruv will talk to that. There is also the point, and if we have time towards the end of our session, we may talk about it. The competent authorities agree to a different meaning pursuant to the provisions of Article 25. This is new, and in the absence of this provision, when a court is faced with an interpretation question, Article 3, Paragraph 2 is pretty clear. Domestic law, unless the context otherwise requires. The agreement of the competent authorities pursuant to the provisions of Article 25 were not relevant in that framework. And of course, Article 25 allows the competent authorities to agree on a meaning of a treaty term, but the big question was, how relevant is that when a court has to judge upon the meaning of a term? Would the court be bound or not be bound by the meaning established by the competent authorities? And the purpose of inserting this addition in 2017 is to give more authority to the competent authority agreement. Interestingly, and then I'll hand over to Dhruv. Interestingly, if you look at Article 25.3, which I have in front of me, it says the competent authorities of the contracting states shall endeavor to resolve by mutual agreement any difficulties or doubts arising as to the interpretation or application of the convention. So this is outside a taxpayer seeking recourse to Article 25. Interestingly, we had a case handed down by the Dutch Supreme Court dealing with a competent authority agreement of the competent authorities of the Netherlands and Germany. The Supreme Court basically ignored that agreement, and the court said, listen, we, the court, already handed down a decision on the specific meaning of this term a while ago, and therefore there is no difficulty or doubt arising as to the interpretation of this provision. So there's a very interesting question here as to the scope of this provision. One final remark that gives the context. So we'll talk in the panel, and by the way, most of the talking after I will have stopped now will be done by Dhruv, Vanessa, and Ajay. But it's not only the challenge here is not only determining the scope of Article 3.2 in the domestic law, meaning in a purely neutral way, but also, and this is what Vanessa will talk about in the second segment of the panel, how can Article 3, Paragraph 2, and the reference to domestic law be used or abused, if you will, by countries, by contracting states to either change the scope of their taxing rights or undercut their dodge, in the term that Vanessa used, dodge their treaty obligation, and how does the good faith interpretation requirement come into play there. With that, it's clear we have a host of issues to talk about. With that, I think I hand over to Dhruv, because I think Dhruv will be talking about the Melford case, I think. Dhruv, the floor is yours.
Thank you very much, Steph, and thank you very much, Mukesh. It is indeed an honor, actually, to be on this panel, because as Steph mentioned, he was my master thesis supervisor and a co-supervisor for my PhD thesis. And one has always looked up to Mukesh from my budding days in international tax law about 15 years ago. Thank you very much. So the slides that Steph has already covered, they cover a host of issues. The first thing I would like to point out is that all the Article 3s in or 3-2s in all the treaties that one faces are not necessarily the same. A lot of the treaties follow the older model conventions, the 1963 draft convention, the 1977, and the various revisions. And until 1995, the explicit reference to the dynamic nature of reference to domestic law wasn't made in 3.2. That came only in 1995. Why did it come over? The first thing, the Melford case is basically where it all started. The facts of the Melford case are rather simple. The Melford Development Inc. had a loan agreement with the Bank of Nova Scotia. But for that loan agreement, it had to seek a guarantee, and it sought that guarantee and acquired that guarantee from a guarantor bank, which was a resident of Germany. For this service, Melford had to pay guarantee fees to the bank. When the tax treaty was concluded in 1956, it did not define the term interest at all. And Article 2, Paragraph 2 of this treaty was more or less the same as the 1963 version of Article 3.2 of the OECD model, where it basically said you look at the meaning it has under the laws in force in the territory of that state relating to taxes to which are the subject of this convention. The Canadian Income Tax Act was amended in 1974 to define interest, and it also included guarantee fees within that definition. So now the question arises, should you now refer to the law, the Canadian law, as it stood in 1956 when the treaty was concluded, or would you refer to the latest law? I would like to take a brief moment over here and refer to Article 2, Paragraph 4 as well. One of the striking things, the first thing that struck me when I read the Melford case was a tax treaty does not apply only to exactly the taxes that are in force or the tax laws that are in force at the time of conclusion. So if one were to repeal and so to say novate a country's tax laws entirely, a tax treaty remains applicable to the new tax laws as well. I don't think it would be fair for anybody to argue that all the definitions and all the meanings under your new tax law are bound to remain the same. Already in this instance, there seems to be an indication that the reference to the laws in force is not necessarily as they existed in 1956, but as they are in force from time to time. But the Supreme Court of Canada thought differently. It adopted the static approach, lest the treaty be unilaterally amended was its concern, and that would not be in good faith. And it also stated that there was no clear evidence of the intention of Parliament that the purpose of the 1974 amendment was to affect tax treaties. So on these two major pillars, the Supreme Court of Canada decided that even though guarantee fees are included within the term interest for the purposes of the domestic law, it does not translate to interest for the purposes of the tax treaty. What was the fallout of the Melford case? Now, this is really quite interesting. Section 3 of the Canadian Income Tax Act was thereafter amended to explicitly mention that all references and all changes to domestic law are going to be ambulatory for the purposes of tax treaties. Now, this was a unilateral announcement that they made. The OECD was also informed of it on 20th of February 1984, very soon after the case came out. Actually, in 1983, it was informed that the case had come out
and then they informed about the response that Parliament had taken to it. And Working Party 1 back then agreed that the reference to domestic law was always intended to be ambulatory. And to the extent good faith was concerned, unless the context otherwise requires would be most important. It, however, did regret Canada's unilateral approach to overturn the court's decision, and thereby its applicability to tax treaties. Now, back then, the OECD was a much slower organization than it is now. I think the whole BEPS movement almost could not have been imagined in those times, and it took a long time. It took 13 years or 14 years for 3.2 to be amended explicitly in the tax treaty. There is a long history of it. Those who are interested, I would highly recommend you can look up taxtreatieshistory.org. It's a site I've contributed to it and digested more than 2,000 historical documents. And one can find a clear line of OECD documents that show that the amendment that we just saw from 1963 that was made in 1995 was in fact only clarificatory, and there is abundant evidence that it was always intended to have an ambulatory reference to domestic law. And which, as I mentioned, with reference to Article 2, Paragraph 4 of the OECD model, which is the case in most real tax treaties as well, makes sense because of the ambulatory reference to the tax laws of a given country. So I will leave it at this for now, and we can perhaps get into the more nuanced discussion later. But maybe Vanessa would like to deal with this interesting case of the Dutch Supreme Court.
Dhruv, just a quick question before we go to this case. Could we go back to the previous slide, please? Yes. So it's clear to us after your description, and the heading of your slide says the fallout of the Melford case. And I think the word fallout has a negative connotation to it. And it could either refer to the Canadian legislation, the overriding legislation, or to the fact that there was a change then in the article itself, 3 paragraph 2. Which of the two are you referring to when you use the word fallout? And I'll tell you in a moment why my question.
Indeed. So it actually is both ways. The reason why I've used the term fallout is because it's a reaction to what happened in response to the Supreme Court decision, and because the OECD did regret it, there was a bit of a fallout from it. It wasn't a falling out of love of sorts between the OECD and Canada, but it was basically a response to the Melford case from all parties. And that's basically what I'm referring to, that on the one hand, there was a unilateral action taken by Parliament in amending, or rather, so to say, clearly overriding the Supreme Court's decision, which is the only way in which in common law countries you can negate a Supreme Court decision because you're bound by precedent, unlike in civil law countries. And Working Party 1 regretted that, and it took a long time, but it indeed was in reaction to the Melford case. Now, I also understand that there are several cases, and we'll come to some later down the line, in India, which have cited Melford as an authority on this issue, but have not really had the benefit of understanding what I call a fallout of that case. And I think that would usually be quite useful to know what the OECD and what the competent authorities and what exactly was intended by the old language. To my mind, there is not much of a difference between the old language and the new language in terms of its dynamic reference to domestic law. I see a question over here by Parveen Dina saying, what is the meaning of ambulatory? And that's dynamic. It changes with time. Sorry, Steph. So that basically is my explanation. I hope I've answered your question.
Yes, absolutely. And in response to that, and also to the question that was raised just a moment ago, I just refer to a part of the commentary. This is actually paragraph 13 on the commentary in Article 3, that says, consequently, the wording of paragraph 2 provides a satisfactory balance between, on the one hand, the need to ensure the permanency of commitments entered into by states when signing a convention, and then it says between parentheticals, since a state should not be allowed to make a convention partially inoperative by amending afterwards in its domestic law the scope of terms not defined in the convention, and on the other hand, the need to be able to apply the convention in a convenient and practical way over time. The need to refer to outdated concepts should be avoided. So there is a balance to be struck here, and clearly the Canadian court in the Melford case found the permanency of the commitments more important, but that, of course, implies the risk that treaty provisions effectively become meaningless because the reference to domestic law could be to something that is totally out of context in the contemporaneous legal context and the treaty. But to make it ambulatory raises the other question between the parentheticals in the commentary, whether that gives sort of a free hand to states to encroach on the other country's rights, to increase their taxation rights. So that's the tension that courts have to deal with, and either do that through the context otherwise requires condition, or perhaps through the good faith requirement in treaty interpretation generally, to which you will all come back later on.
I fully agree with you, Steph. I think it is abundantly clear. I remember actually at IBFD there was a debate between Professor Michael Lang and John A.V. Jones, where they both have taken extreme positions, and I believe that those are perhaps their real positions and not just for the debate. I'm not entirely sure. Where A.V. Jones was of the opinion that unless the context otherwise requires, has no meaning at all, and Professor Lang had has actually the stated position, even in his literature, that the context always requires otherwise. Now, I think these are both extreme positions, and a balance has to be struck. From the historical references, it is quite abundant that when they were drafting this, unless the context otherwise requires, indeed had the need for having some degree of permanence. And I think that permanence is to be defined by good faith. What is in good faith and what is not. And therefore, at this stage, I stated what Melford said and what the outcome of Melford was at the OECD. Almost every delegate at the OECD Working Party 1 back then agreed that the Supreme Court decision was inaccurate. And that's sort of a situation where a term is entirely left undefined and the domestic law has been altered to define a term would not be seen in bad faith. And that is basically where I think is the difficult job of judges and advocates about how do you find and how do you identify context and good faith. And I think the Dutch case is a fairly fine example of how a court could go about this business.
Yeah, that's a nice segue. I should say that your follow-up discussion reminds me of the difficulties around the interpretation of the term beneficial ownership, where courts have struggled and where countries have introduced a domestic law meaning in the hope that through Article 3, Paragraph 2, that meaning would control the interpretation of Articles 10, 11, and 12. And then I think following or caused by the Prevost case in Canada, probably mostly, the commentary was amended and it said almost literally, of course there is a contextual interpretation here, because when the term was introduced in the OECD Model Convention, the term did not have a meaning in the domestic law of the various countries. And this is still a highly debated theme, of course. But let's move into this Dutch case, which, by the way, I'm not sort of taking or abusing the prerogative of the floor here, but we agreed in advance that I would deal with this case, I guess because it's a Dutch case. So here we have a Dutch BV, ex-BV, tax resident in the Netherlands. It's 100% shareholder. An individual is tax resident in Belgium, and the company pays director's fees to the resident of Belgium, but to a fairly limited amount. And normally, if director's fees are paid to a resident of another country, depending on how you would look at the director's fees and make a distinction between the director's fees as such and ordinary compensation for dependent services or employment income, as we say these days. Different articles of the convention apply, and the country of residence of the paying company may have a taxation right, or the country of the residence of the recipient of the income. Now, totally outside the treaty context and totally outside the international context, a rule had been introduced in the Dutch Income Tax Act that prescribed a minimum income for an employee who would also be a substantial shareholder in the company. And the background to that rule is fairly easy. A substantial shareholder, and certainly a 100% shareholder, would have it in his power to determine basically the employment income, the compensation for services. And as the corporate income tax rate was fairly low at the time, certainly compared to the individual income tax rate, and the possibility to defer further individual income tax by not distributing or not having the company distribute income, there was a significant benefit in taking out a low salary by the director/shareholder, have the company accumulate its earnings, and then perhaps realize these earnings at some point in the future with a sale of the shares. And the capital gains tax in respect of the sale of the shares would then be lower than the income tax that would have been due if the earnings would have been paid out as a salary. So this was really arbitrage between company taxation and individual income tax for the individual. In order to counter this arbitrage possibility, a deeming rule was introduced in the Dutch Income Tax Act, and the deeming rule basically said that the minimum salary that the shareholder employee was deemed to have received was the lowest salary for an equal job or equal kind of service provided to the company by another employee. And in the year at issue, the amount paid out to the individual was, as you see on the slides, 78,000 euros. But the deemed income, and I got it wrong on the percentage, it should be at least 70% of the customary salary, to be more precise for similar employment. The income resulting from the deeming rule was 150,000 euros. So in the domestic context, this is a coherent system. In the cross-border context, the question then is the the top up of the salary under the Deeming Rule? Is that then also salary for or employment income for the treaty application? And the Supreme Court, I have to back up here a little bit and do this in bits and pieces so that it also leads up to the Fowler case, which I think Drew will be talking about. So if you look at Articles 15 and 16 of the treaty, it's about income from, let's focus on 15, income from employment. Of course, there are undefined terms in there. So income and employment, through Article 3, Paragraph 2, you would go to domestic law, determine whether there is an employment relationship, when they're under domestic tax law. This would be employment income, and then you apply the distributive rule of the treaty. The question is, if the employment income, so that all is fairly straightforward. If the employment income is then a different amount from the amount that is actually agreed upon and paid and includes a deemed amount, is that deemed amount then also income for the purposes of interpreting Article 15 or 16 for that matter? And the Dutch Supreme Court followed Article 3, Paragraph 2, applied domestic law, and also said almost literally, once you're in scope of the employment article, that is also true for any amounts deemed received by the taxpayer, unless it would lead to a different allocation of taxing rights as between the two contracting states. And the other state would not have an equivalent deeming rule and would not have known about this deeming rule at the time the treaty was negotiated. Now, what exactly does this mean? The balance of taxing right or changing the taxation rights. It means the following. Assume that this Dutch the individual director, the resident of Belgium, had not been, the salary had not been topped up with the deemed amount. So the 97,000 that is displayed here in green, if that amount is not paid out to the resident of Belgium, but it is retained and accumulated by the BV. If at some point in the future the resident of Belgium would then sell the shares in the BV, the value of those shares would be higher to an amount of 97,000 because there would be more cash in the company. Question is, which of the two contracting states would get to tax that higher amount? The general rule under Article 13, ignoring for a moment some particular anti-abuse rules that some Dutch treaties have, but the standard rule is that shares, other property in the language of Article 13, would be taxable only in the resident state. So the question is, if this deeming rule would be applied and the 97,000 could be taxed in the Netherlands, because that's the country of residence of the payor of the director's fees, or perhaps because of the employer that bears the cost, or a permanent establishment, doesn't matter. Under the deeming rule, that's the point here, the country of the payor, the Netherlands, would get additional taxation rights if that deeming rule would also be followed for the application of Articles 15 and 16. Whereas if it would have translated into a higher capital gain, or even a dividend, under Article 10 or Article 13, the country of residence would have had a taxation right. So the test that the Supreme Court applied here is, if the Deeming Rule would apply for purposes of the treaty, would the taxation rights in substance be shifting? And if that would be the case, then that would be contrary to the principle of good faith, according to the Supreme Court, and the Deeming Rule would not be followed unless, and the unless is the other country, so in this case Belgium, would have an equivalent Deeming Rule, or the Deeming Rule was understood to exist by the other contracting state at the time the treaty was negotiated. So there is an interesting, and Drew alluded to this already, there is an interesting interaction between Article 3, Paragraph 2 and the contextual, the requirement of the context, and the good faith. And it's still not entirely clear whether the Supreme Court took a contextual approach or whether the contextual approach maybe was not so relevant and applied directly the good faith requirement of the Vienna Convention. So let me stop there with this case and see if any of the other panelists would wish to chip in on this particular case before we go to the next case.
I would, with the permission of the chair, can I just pose one question which also the panelists can take and you can also take? It's an interesting question. It says, is the unilateral amendment enough to be considered as context under Article 31 and 32 of Vienna Convention? Sorry for the interruption.
Yeah. Thank you, Mukesh. Maybe we move to Dhruv and Vanessa or Ajay, and then we make sure that in doing so we address your question, Mukesh.
All right. I just wanted to make just a few comments. First of all, I would like to thank IFA India for inviting me and for proposing this interesting topic. I think that the big discussion at the background was whether the deeming provision or the fictitious income provision changed or made it the country shift from the application of Article 10 or 13 to Article 15 or 16, which were more beneficial to the Netherlands. And the discussion was whether by including this provision, the Netherlands tried to impact the treaty in a way to extend its taxing rights and therefore would be against good faith. What I find interesting in this case is because it's not only about a recharacterization of the income, but also about a fictitious payment. So you have two elements there. And if we look at the decision given by the Court of Appeals, the decision that was appealed to the Supreme Court, in that decision, what was referred to was the fictitious payment wouldn't fit any of the distributive rules because there was no actual payment and there was no income that was derived. So because of that, it would fall into the scope of the other income article. That was the solution that the Supreme Court, the Court of Appeal had. So they decided to qualify that fictitious income into other income, and therefore we would have only taxing rights granted to the resident state, which was Belgium, and then the Netherlands couldn't tax. So in the end, the result of that decision would be in a way to prevent the taxation in the Netherlands. But because the other income article of Belgium and Netherlands attributed all the taxing rights to resident states, it wouldn't happen, for example, if we were with countries that would follow the UN model and would have allocation of taxing rights to the source state. So if we had that scenario, the Netherlands would be able to tax. But that was the decision of the Court of Appeals. So the Court of Appeals denied the qualification into the distributive rules. So it was neither in 10 or 15 or 16 or 13 because there was no payment. but it would be qualified as other income. So the Supreme Court didn't follow exactly this line of thought. They just applied the good faith and said that the deeming provision would result in the extension of taxing rights of the Netherlands that was not, let's say, intended when they signed the treaty back then. So that was the comment I wanted to add.
Yeah, and it's a very important comment, Vanessa. And it seems that the Dutch Supreme Court has a somewhat troubled relationship with the other income article, because they also on prior occasion, they try to find a closed system in a particular treaty provision or a set of treaty provisions. So they almost see this as solely playing out in the scope of Articles 15, 16, and 10 and 13. And they did the same a number of years before that with a dividend paid by a company that was resident for domestic purposes but non-resident for treaty purposes, and they did not mention the other income article. So I have heavily criticized that decision. I think when you can get to the right result in a textual interpretation of the treaty, that is probably the better way to go. But in this case, as you point out, the Supreme Court used language to the effect that the deeming provision would not produce income that would be visible for purposes of Article 21, which was an interesting consideration by the court.
On that point, Steph, there is another decision of the Dutch Supreme Court which touches upon income from immovable property. Like in India, there is a deemed income from immovable property if you don't occupy a house or if you have a second house. It's not exactly the same as the rule in India, but it is similar. And the issue arose over there that this deemed income that one has, is that income from immovable property or is that other income? Over there, the Supreme Court, again, like in this case, held that it would fall within Article 6 and not Article 21. But I think over there, it may seem counterintuitive to start with, but if one takes a step back and even asks oneself, what is income? Is that even a real economic concept? I would think otherwise. I mean, the way income is computed is entirely a fiction of law. What depreciation you can claim, or what entertainment expenses are, how they are limited, what medical expenses you can deduct from your income for the purposes of tax, is all a matter of law. So, to my mind, the Court of Appeal was perhaps treading on thin ice over there, if I can be provocative, in saying that if it's not real, then you need to go into Article 21, and it's not, of course it's income, but it's not income from real estate, or in this case, employment. If one reads Article 16, it says income derived in one's capacity as a director. This addition of 97,000 guilders in this particular case was because of his capacity as a shareholder and director's fees, or at best as his salary. It is in respect of an employment. So I think the treaty is quite broadly worded in that respect to sort of immediately look to 21. And it's an interesting comment you made, Steph, about if one can achieve the right result textually, then one must not look at extra textual modes. And I fully agree with you over there. But then also one asks the question, how does one determine what the right result is?
Yes, let's do a separate seminar on that. But it is a good, I mean, this really goes to the point whether there is such thing as a purely textual interpretation, I guess. But before we move on to the next case to respond to Mukesh's remark about the context. And I hope I got your question right, Mukesh. I think what the reference to good faith by the court, I think, is a direct reference to Article 31, 1 of the Vienna Convention, and probably not a reference to the context as the Vienna Convention would mean with context. So this would be straight to Article 31.1 of the Vienna Convention, and the question I had as to good faith and context would be not the Vienna Convention context, but the narrower meaning of the 3-paragraph 2, unless the context otherwise requires context. And I still don't know which avenue the Supreme Court took. I'm inclined to think they went straight to the good faith requirement of the Vienna Convention.
Actually, it was something that Vanessa and I were discussing just the other day.
Okay.
What could have allowed the Supreme Court to get into good faith? And I think we both agree with you, Steph, that they went straight into Article 31. But if one takes a step back and just imagines a 3.2, which does not have the words unless the context otherwise requires, and says that undefined terms shall have the meaning they have under domestic law, in that case, there would be no room to look anywhere outside of domestic law, because that would be the context of the treaty. There's a very clear textual rule which says, look at domestic law. So I think you can get into good faith arguments. You, of course, even read that Article 3.2 in good faith, but to have a direct reference to domestic law in that case would be in good faith. To divert from the domestic law definition, there has to be an outlet, and the only outlet 3.2 very clearly in its text allows is unless the context otherwise requires. Hence the last bullet point over there, which says that access to good faith in tax treaties to avoid only for the purposes of domestic meaning, I'm not talking about for all other purposes, is possible most likely only via unless the context otherwise requires.
Yeah, although, and perhaps Vanessa will get into that towards the end of our seminar, I guess, unless you would bring in object and purpose of Article 31.1 of the Vienna Convention and see an opening there, because this, in a way, it gets to the prior point of textual versus, object and purpose. Let's not go there, because I realize we are already on top of the first hour of our seminar, and certainly after. So I forgot who would be dealing with the next case that we had.
It's Fowler.
Yeah, Fowler, and we have to make sure that Ajay gets to address the Indian cases and has ample time for that as well. And then, of course, the treaty dodging with Vanessa. So, Dhruv, let's move into...
If I could just one small comment in respect of the good faith there, because we've been discussing me and Dhruv about it, and actually, for me, good faith and all the rule of interpretation of the Vienna Convention apply to Article 3, Paragraph 2, regardless of the unless the context otherwise requires. Because I know that there is this discussion that the Article 3, Paragraph 2 is a lex specialis, but I don't think that it would preclude the application of Article 31 in this sense, because it would only preclude if there would be conflict, but it's just an addition to Article 31. So I wouldn't see a problem of making a reference to good faith directly to the Vienna Convention and not through unless the context otherwise requires.
Perfect. Thanks. Dhruv, I think we're back to you.
Okay, right. So thank you again. Very quickly. So the facts of Fowler. This is the very recent case which has been adjudicated by the Supreme Court of the United Kingdom. So Martin Fowler was a resident of South Africa, and he was employed as a saturation diver for oil exploration in the UK continental shelf, presumably and necessarily actually by a UK resident company. And so therefore, the exercise of his employment was entirely within the United Kingdom. In 1977, divers threatened to go on a strike. Why did they threaten to go on a strike? Because they usually bore their own expenses, travel, accommodation, etc. And there was a revenue ruling which said they would treat them as employees. Once you're an employee, you don't get business deductions, and you're taxed on the gross amount of your salary with limited deductions. So in that particular case, they threatened to go on strike, and in response to this threatened strike by the unions, in 1978, the Deeming Fiction was created, where divers working on the continental shelf were treated as if they were self-employed, and deductions were therefore granted accordingly. Accordingly was another expression used in Section 314 of the Income and Corporation Tax Act of 1988. In this particular case, there was also some losers. The benefit was not extended to non-domiciled divers who were employed by non-residents, but that's a slight part. So there was a bit of a mismatch. Not all divers got this benefit. Now, because they said as if, it was clear that they were indeed employed, but they were just going to be treated as if they were self-employed. This law was rewritten in 2002. Well, not entirely in 2002, partly in 2002, partly in 2003, partly in 2010. And this has some relevance to what's going on over here. Let's see if there was perhaps an unintended change of what the law provided for. Now, there was the Income Taxation, Employment and the Pensions Act, the ITPA 2003, which defined in the employment income part, that is a certain part of this particular act, that employment includes in particular an employment under a service of contract. So it's quite clear that a service of contract for a certain part of the tax law of the UK would be employment. Section 6.5 of the ITPA again said, employment income is not charged to tax under this part if it is within the charge of ITOIA 2005. ITOIA is Income Tax, Trading and Other Income Act 2005. By virtue of Section 15 of that Act, being the ITOIA, which applied to divers and diving supervisors. Now, if one looks at this language of 2003, it's quite clear that they're talking about employment income and the treatment thereof. Yes? But a couple of years down the line, how was the deeming redrafted in ITOIA Article 15, Paragraph 2? Where they stated the performance of the duties of employment is instead treated, and important words are, for income tax purposes. Now, the moment you say the purpose of this fiction is for income tax purposes, it covers everything, not just the limited coverage of Section 4 of ITPA, which was only for the employment income parts. And this would be treated for income tax purposes as carrying on of a trade in the United Kingdom. And this treatment is not computational. This treatment is not the treatment of employment income, but this treatment is the duties of employment are treated as the carrying on of trade. So there is really a shift from as if to what it is deemed to be, and that too for all income tax purposes. So now, the income tax purposes subsumes the employment income parts, and it includes tax treaties, which again are given effect in the UK, unlike in the Netherlands, through a domestic act, which is the TOIPA, which is Taxation of International and Other Provisions Act 2010. So this is basically what has happened. The interesting part now is, can you read this deeming fiction into tax treaties? Now, the automatic response that most people would have, hey, if you treat it as employment, then the UK has taxing rights under Article 15, presumably because the exercise of the employment is surely in the UK, and the employer is a UK resident, or that because the employee spends more than 183 days, and therefore would be liable to tax in the United Kingdom. But if it were treated as a trade, then in that case, since the place of business would not be that diver's own place of business, it is highly unlikely that a diver should have a permanent establishment and the UK would not be able to tax. Now, in this particular case, how far do you go? How far do you apply the deeming fiction? If you apply the deeming fiction by saying that the duties of employment are now treated to be the carrying on of a trade, then you would say you apply Article 7. On the other hand, you could say, no, that is just a deeming fiction. You have employment income, which is because it is an income in respect of an employment. Now, this is basically where the conundrum really begins. And I think there is an inherent tension in the piecemeal way in which the law has been rewritten. Because think about it, if you have the duties of employment, which are the carrying on of a trade, but that carrying on of a trade arises from an employment as defined in Section 4, then you have an employment, but there are no activities carried on under that employment. And therefore, it was submitted to the court that for the purposes of this particular deeming fiction, one can harmoniously interpret the treaty as saying that for the purposes of divers and diving supervisors, look only at 15.2, and Section 4 of ITPA simply does not define employment for those purposes, because the deeming was for all income tax purposes, and it has taken it outside the scope of the employment income parts of ITPA. Now, in this sort of a situation, it would be interesting to examine whether there could be any lack of good faith. Now, in the other cases that we saw, Melford and the Dutch case, the effect of the deeming fiction was that that deeming country would claim taxing rights, or would claim taxing rights over income which it did not, it wouldn't have been allowed before that deeming fiction. In this particular case, the UK would basically be giving up its taxing right. If a country intentionally or inadvertently changes the meaning of a term and loses taxing rights, can that be called in bad faith? So I would like to pause over here and ask that questions to the other panelists. To my mind, no, it couldn't be. I think all the other panelists agree with me.
I also agree with you. I don't think there is an issue with the good faith that actually it was one of the reasons why it took me a while to understand this case, because I was so much used to read cases of deeming provisions that they were all drafted by states trying to extend their taxing rights. And in this case, it was not like that. Like the deeming provision led to a worse result to the UK. The UK didn't draft that legislation with the aim of trying to alter the balance of the treaty. It was for another reason. So for me, it was difficult I had to set up my mind and to try to understand. But because of that, I don't think there is an issue with good faith. Good faith wouldn't play a role there, at least at the level of the countries or public international law.
I think Ajay has a comment. Yeah.
I don't think this is a question of good faith. As I see it, I don't think the United Kingdom consciously or intentionally intended to give up its taxing rights. It's just that it made those changes in their domestic law. And as a consequence, the court has interpreted the provision as meaning that while it may be carrying on of trade in the United Kingdom for UK domestic tax law, for treaty purposes, since there was no permanent establishment, Article 7 did not kick in, and therefore the diver was not liable to tax in the United Kingdom. If this case came to India, I think it would have been argued very differently. The revenue would have said either you choose to be taxed under the Act or you go under the treaty, whichever is more beneficial to you. So if you choose to be or opt to be taxed under the Act, then in that situation you are carrying on trading in United Kingdom or in India, and you are therefore liable to tax in India without anything more. If you decide to go under the Act, this income will probably be characterized as employment income. And since this is exercised in the other state, it will be subjected to tax in accordance with the rules relating to employment income. I don't think any country intended to give up its taxing rights when making these unilateral amendments in their domestic legislation. This is a consequence that has come about as a result of the interpretation placed by the Supreme Court of United Kingdom. But clearly, I don't think this is the last word, and courts of different jurisdictions are free to interpret a similar situation in a different manner. But interesting times, I think it's an interesting converse situation. Yeah, as you very rightly pointed out, a converse situation.
Mm-hmm. That's quite right indeed. So I don't think good faith is really the issue over here. But I wonder if really context plays a role. Because I've been reading and rereading this case, and it has perplexed me every time I've read it. Because there are several references that it has made to the OECD commentary as well, and it refers to Article 8, paragraph point 11 of the commentary on Article 15, where they're really talking about the concept of formal employment versus economic employment. And it sort of suggests, and if I could read out that provision, I have several versions of it. One moment, yes. This is at paragraph 17 of the Fowler case, the decision, and it points out the fourth sentence of section 8.11 of the commentary on Article 15. It says, conversely, where services rendered by an individual may properly be regarded by a state as rendered in an employment relationship rather than as under a contract for services concluded between two enterprises, that state should logically also consider that the individual is not carrying on the business of the enterprise. This is quite interesting because in this very paragraph, it says there are two qualifications to looking at domestic law. One is context, and then it says, then it does not comment anything about context, and then goes on to this commentary. But my point over here is that if the Supreme Court is indeed relying on this particular commentary, perhaps it thinks that there is an autonomous meaning of the term employment. There's and that is sort of enunciated or articulated by this given commentary. And I think that is the only way in which it could have arrived at this particular outcome. The other reason why it also says is that the purpose of the domestic definition was not to alter the allocation according to the treaty. And therefore, it should have a real-world meaning. Now, this reference to the real-world meaning was also something that perplexed me very much, because what is the real-world meaning of any legal concept in the end? I'm pretty sure that most countries will have their own ideas of what an employment is or what a business is. And what might have also helped a little bit more if the court could have perhaps looked into how the OECD has consistently, right from the very beginning, thought of the term business. Now, business is a term that we take for granted. We think we know what business is. But if one looks at the term business as has been partly defined in the, the term enterprise as has been partly defined in Article 3.1h, it talks about the carrying on of any business. And then the commentary on the interpretation of the term business states quite clearly at paragraph 10.2 of the commentary on Article 3 that business is an undefined term and should be construed by reference to domestic law. So in this particular case, they've looked only at the commentary on Article 15 and haven't looked at what the OECD says about what the interpretation of the term business was. I don't have an opinion per se about whether this is a right decision or not, and I don't even think that's very interesting. But what is interesting is how the court might have come to this particular outcome. And I think the way the decision has been written, it might perhaps have left a few loose ends, and I'm not entirely sure what exactly the reasoning of the court was and how it construes what a real-world interpretation of business or employment is per se. What might have also played into the court's psyche was something that they constantly question the counsel in their during their submissions, was the effect of double non-taxation, because South Africa, for divers specifically who were employed abroad, had an exemption of foreign earned income, and so under their domestic law they would have not taxed the income, and because of this deeming fiction, it was possible, as the Court of Appeal had indeed held by majority, that the UK could also not tax because they were bound to apply Article 7. Now, in this particular case, there would be double non-taxation, which the court, I don't think per se, wanted to avoid as a means of anti-avoidance, but I think the court might have been concerned about a conflict of qualification. And where you have one country treating an item of income as employment, being South Africa, and another country, the UK in this particular case, treating it as business profits, and it leads to double non-taxation, the court wondered at many an occasion if this conflict of qualification, not in as many words, was to be dealt with only by reference to domestic law. I don't think this was necessary because indeed the treaty provided for the credit mechanism anyway, and there is enough commentary in the OECD commentaries to suggest that in case of a conflict of qualification, the residence country follows the qualification of the source country, and if the source country does not want to tax it, the residence country, all it has to do is grant a credit of 0 and tax it under its own domestic law. That's what a treaty does. So I think there are several loose ends in this particular decision. Initially, I thought the court went straight to Article 4.1 and basically said the term employment has been defined. This is a contract of service, and therefore also for treaty purposes, it's employment. But more and more that I read this decision, I think it might have subconsciously relied on context by referring to the commentary at 8.11, which again is perhaps suspect. Those are the thoughts that I have about the Divers case and the Supreme Court decision thereon. I think it's fascinating, and I would very highly recommend also reading the Court of Appeals decisions, both the majority and the dissent. It's an extremely useful resource in this respect.
Two quick remarks, if I may, Dhruv. One, and that had not occurred to me when I read the case, but the reference to this particular paragraph of the commentary, enterprise to enterprise or employment, almost, but I have to revisit this, looks as if it could have been taken out of context. You talk about context, but then context in the plain language meaning of context.
Yeah, absolutely.
Yeah, and the second remark is if I compare this outcome with the outcome in the Dutch case, there is an interesting difference because in the Dutch case we had an employment relationship of a director. We knew that that would be covered as such by Article 15 or 16. And then the question was whether the deemed income would or would not be covered by 15 and 16. In the Fowler case, we have an employment. That employment is also recognized as an employment for the purposes of application of the tax law. But then it says, but we will tax it under a different provision of the code. And if you then look at the literal wording of 3 paragraph 2, that the term will have the meaning it has under the domestic law, if you apply that precisely, you could say, well, the term that we are interpreting here is maybe salary, employment income, employment, and clearly the meaning has been established under the domestic law in the UK, and how the income is then taxed under which provision of the code, even if it's completely elsewhere, maybe as a capital gain, I'm just making this up, is then irrelevant for application of the treaty. That's a thought that came to my mind as well. But I have not focused on for certain it's a difference, I think.
If I could.
I think we're waiting for you, Vanessa.
Yes, sorry. I think I had a problem with my internet. Can you hear me?
Yeah. Yes.
All right. So, Steph, actually, I completely agree with you. And when I was reading the case, I remembered that the definition for dividends under Article 10, paragraph 3 shows exactly this difference, because there, and I have here, you have the definition of dividends, and you would have also a reference to dividends is also income from corporate rights, which is subject to the same taxation treatment as income from shares. So in this sense, you see that there is a reference to the tax treatment, which is not in Article 3, paragraph 2.
Yeah,
so
absolutely.
You could emphasize that Article 3, paragraph 2 is not about the treatment, but about the definition or the meaning.
Yeah, fully agree.
I agree insofar as treatment is concerned.
Yeah, we have to be mindful of time and perhaps move on to Ajay with the cases if you're all fine with that. Thanks, Mukesh, for reminding us, because it's easy to forget the time.
Thanks. So I will deal with a part of it. I think Mr. Vora wanted to also make a comment on it about some Indian case law. We can go ahead with it. But the point is about the India-Netherlands Tax Treaty. The term royalties is interestingly defined in this, where it talks about the term royalties as used in this article means payments of any kind receives as consideration for the use or the right to use of a secret formula or process. Now, in satellites use processes which are, anyone with a school education should know how a satellite works in principle. So it's not really a secret process that a satellite uses. And Article 916 of the Income Tax Act uses a very similar definition of royalties and says it is any consideration for the use of a secret formula or process, trademark, or property. Now, if you notice over here, a comma has been used after process in the treaty, and no comma has been used after process in the domestic definition. So the question basically has arisen, does the adjective secret apply only to formula, or does it apply also to process? Now, there are a host of decisions which have relied on that comma, and there are decisions where 50, 100 pages have been used in just figuring out what that comma or the lack thereof in domestic law might mean. But I'm going to ignore that comma for a moment. There was a 2012 clarification with retrospective effect from 1961, wherein Parliament said, for removal of doubts, it is hereby clarified that the expression process as used in the domestic definition of royalties includes and shall be deemed to always have included transmission by satellite, whether or not such process is secret. Now, clearly the term definition has been defined, but secret formula and process or process has not been defined. Now you have a clear domestic provision, and therefore 3.2 becomes relevant. How do you interpret secret formula or process? And over here, if you apply Article 3.2, it would seem that there is a good case to be made, comma notwithstanding, that indeed the adjective secret should not apply to process. And there are conflicting decisions in this respect under domestic law. The Madras High Court in Verizon has said even payments for non-secret processes, including satellites, are royalties, and then all the other decisions have said no, they are not royalties for treaty purposes. Is there any treaty context which makes it quite clear? Now, obviously, I'm talking about it, and I think there is. If one looks at the 1989 India-Netherlands Tax Treaty, that has been concluded in Hindi, in Dutch, and in English. Each version is equally authentic, and it says the English version is operative if there is a divergence between Hindi and Dutch. Now, in this particular case, and as in almost every treaty case that I've come across in India, court references exclusively to the English versions. In Hindi, it says Gupt formula ya prakriya. But again, the same question arises. The term Gupt, does it qualify formula and prakriya, or does it only qualify formula? The Dutch version, however, gives us a clear indication. It uses een geheim recept of een geheime werkwijze. Now, why have they used the same adjective for both nouns? Yeah. Now, the reason is quite clear. All nouns in Dutch are either gendered or they don't have a gender. And in this, and the way you spell the adjective changes with it. Recept is a gendered noun. Steph, correct me if I'm wrong. I think it's male. And so it says een geheim. And when it, or is it the other way around? Right, I think it's the other way around. And werkwijze is male. And over there, you have to add an E at the end of the adjective for it to be valid. So over here, linguistic necessity said it has to be a secret formula or a secret process. Now, over here in a multilingual situation, is there a divergence between the Hindi and the Dutch versions of the treaty? And do you then go to the English version, which is equally problematic? Well, I don't think you can really see divergence that lightly. Over here, as we see, the double use of the adjective was out of necessity, and it is not mutually exclusive from the other wording, or in Hindi or in English. And there is more evidence to suggest that this divergence is not really a legal divergence and should not be seen as material. Because if you look at the French version of the OECD model, Article 12, paragraph 2, it says, d'une formule ou d'une procédé, secrets. There's an S at the end of it. Now, that is again a nicety of the French version, where the plurality applies not only to nouns, but also to adjectives. and secrets over here necessarily applies to both formula and process. And I looked at other treaties that India has. So the Dutch version and the French versions of the Belgium-India Treaty, again, uses both the adjectives geheim and geheime in Dutch and secrets in French. And there are 5 other treaties in which the term secrets in the French versions of all the Indian tax treaties, which also have French versions, use the plural, so as to suggest that there is indeed an international tax autonomous meaning where secret should, in the context of a treaty, apply both to formula and to process. And therefore, in this particular case, we can rubber stamp it and say that context requires otherwise. I want
just on language, Dhruv. So the recipe is neutral, and the way of working is female. Just the other way around.
Yeah.
No worries.
I still have to master Dutch with female and male. Ajay, did you have any comments on this?
Yeah.
No, we may have, unless it's Ajay, but I think we have to move to Ajay. Yeah.
I was wanting to raise a larger issue. I will move away from the secret formula versus process and the comma. That the term royalties is defined under the treaty. Now, can you therefore say that the term is not defined because royalty includes use, payment for, a secret formula or process, irrespective of the comma, irrespective whether secret is used with the formula or process. So the definition is of the term royalties. Now, can you in that context enlarge the definition by unilaterally amending the domestic law and say that therefore in terms of Article 3.2, you need to read the domestic law as enlarging the definition of the word royalties or the word process, which is a subterm used in the definition of royalties. To my mind, as I would see it, we need to look at the term royalty. And if you look at 3.2, it says if a term is not defined, and if you look at the dividend article, the interest article, the royalty article, it says the term dividends, the term interest, the term royalty means so and so. So I would think that notwithstanding there is no definition of secret formula or process, you cannot borrow that definition from the domestic legislation. That's my first point. The second, in the Indian context, the definition of royalty starts in explanation 2 to section 916. It says, for the purposes of this clause, and it is defined in explanation 2 to 916. Now, those definitions in explanation 2 have been enlarged by these artificial extended meanings given in explanations 4, 5, and 6. Now, therefore, in my understanding, it only seeks to amplify, enlarge, clarify, whichever way you want to put it, what is intended in explanation 2 to 916, which is again only for the purposes of 916 and not for purposes of the treaty. So that's one view that I would take, that you cannot read it as part of the treaty. Second, as I think the question that Mukesh raised, this would be purely a case of unilateral treaty override. The word royalty has been understood in a certain manner. By making a deeming provision in our domestic legislation, making it retrospectively applicable, you are seeking to unilaterally amend or override the tax treaty that was signed between two sovereign countries, having a particular understanding of what is the meaning to be imparted to the word royalties. So therefore, I would take the view that, and as the courts have held in the various judgments that you have pointed out in your footnote, they have taken the view that the enlarged definition cannot be ipso facto read as part of the treaty. And therefore, one will still have to be governed by the definition of royalty under the double tax treaty, which is much narrower, restricted, truncated compared to the definition under the domestic law. Yes, Verizon has struck a discordant chord by taking a contrary view, and there is actually no reasoning in that judgment. They said the definition of royalty under the Act and under the treaty is similar, it is pari materia. Not reading the definition of royalty as was defined in Article 12.3 of that particular treaty. So therefore, I would tend to take the view that notwithstanding the retrospective amendment made by the Finance Act of 2012, we would still be governed by the definition of royalty as provided in the treaty, and the context does not require otherwise for us to read the income tax definition under the domestic law as part of the treaty definition.
Great. Thanks very much, Ajay. Just in the interest of time, because we have, if I follow the clock, literally 25 minutes left, but Mukesh kindly, through a private chat, let me know we could spend an extra 15 minutes. So we have, around 40 minutes, but maybe we allow a little bit of time to take some questions from the audience. So maybe we divvy up the time, say 10 to 15 minutes for the cases, and then 10 to 15 minutes for the treaty dodging, which I think is really important, and then we take some questions. Would you all be fine with that approach?
Yeah.
So, and shall we move right to the Sanofi case?
Sure. I will move towards the Sanofi case, and I will skip this one.
Yeah. Because I think Ajay was going to deal with the Sanofi case, isn't it?
Yeah, I will just come back to the previous slide on the Sanofi, which describes the structure. Yes, Thank you. So in this Sanofi case, as you can see, Sanofi controls this company Shanech in France, which in turn holds about 82.5% in an Indian company. Now there was the sale of shares of Shanech, which in turn held the Indian company and derived substantial value from the shares in the Indian company. And the question arose whether the capital gains from sale of shares that was earned by Shanech could be that was earned on sale of shares of Shanech could be brought to tax in India. Now, in the meanwhile, in the meanwhile, what had happened was there was a retrospective amendment by the same nefarious Finance Act of 2012, by which explanation 5 was added to section 911 to provide that if the shares of a foreign company derive substantial value from shares held in an underlying Indian company, then in that situation it would be treated as income arising from sale of shares situated in India or capital assets situated in India. Now that amendment that was brought about was post the Vodafone judgment, and prior to that the position in law in India was that income from transfer of shares situated in India was liable to tax in India. It was deemed to accrue or rise in India. Now shares were treated to have situs in India if the register of members was kept in India. Explanation 5 seeks to enlarge the situs of shares by saying that if even the shares of a foreign company, which are located admittedly outside India, derive substantial value from shares held in an underlying subsidiary or Indian entity, then in that situation, the sale of shares of the foreign company would be treated as shares situated in India, and therefore capital gains arising would become liable to tax in India. Now, the Indian revenue, in the case of the Sanofi, raised this particular argument that you have to read explanation 5 in terms of Article 3.2, and therefore the capital gains earned by the French company on sale of shares of a French entity should also be liable to tax in India. This was rejected by the Andhra Pradesh High Court, holding that A, having regard to Article 14.5, and that article dealt with alienation of shares representing a participation of at least 10% in a company which is resident of a contracting state. So the court held that two important issues that need to be considered is one, alienation of shares and representing a participation of at least 10% in a company which is resident of a contracting state. And the court negatived the contentions raised by the revenue, holding that the alienation of shares of the French company could not be regarded as a deemed alienation of shares of the Indian company. And for that purpose, again, the contention raised by the revenue that the word alienation must have its meaning as defined in section 2, subsection 47 of the Income Tax Act to include extinguishment of rights in a capital asset would not be read into Article 14.5 of the India-French Double Tax Treaty. So, according to the Andhra Pradesh High Court, it could not be said that by selling shares of Shan-H, there was a delineation of shares held in Shanta Biotech, and in that view of the matter, it was not possible to apply Explanation 5 to bring the capital gains to tax in India. And the court also alluded to the Melford judgment from the Canada Supreme Court, also took into account the good faith argument based on Article 31 of the Vienna Convention, which was taken note by the Supreme Court in another judgment in the case of Ram Jethmalani. So this was the Sanofi view, against which the Revenues SLP is pending in the Supreme Court. And in my view, the court has taken the correct decision that Explanation 5, which alludes to a completely different concept of capital assets situated in India. It nowhere, in fact, even if you look at Article 3.2 and if you look at a term not defined, here the term in Article 14.1 is alienation of shares. Now, this is not a term which is defined, which is not defined under the treaty, but is defined for purposes of the Act. We don't have a definition of the term alienation even in our domestic legislation. So even if the resort is had to Article 3.2, one cannot hold that Explanation 5 to Section 9.1 is referring to alienation of shares to bring this in within the treaty definition. So this was the Sanofi judgment. And then we had the subsequent judgment which followed Sanofi.
Just a quick question, Ajay. Just a quick question on Sanofi. You say that there was a reference to Melford.
Yes.
In your view, does that reference mean that the Indian court would also favor static interpretation, or was it just to remind us that there is a permanency of commitments and that you cannot easily sort of stretch the scope of a treaty provision out of its ordinary position?
Yeah. So I think in this context, it is not that the court, adopted either the static or the ambulatory approach, but the court did take into account the fact that this see-through approach, which is the see-through logic, which is there in Explanation 5, does not fit into the scheme of Article 14.5 of the India-French Treaty, which talked of capital gains on alienation of shares of a company resident in one of the contracting states. And they also said that this look-through approach can be applied to the previous paragraph of Article 14 with respect to alienation of shares of a company owning immovable property. So they did, in that sense, apply an ambulatory approach when they took into account Explanation 5 to Section 9.1 to test whether it applies with respect to Article 14.5 and ruled out its application. So to that extent, the court did look into an ambulatory approach, if I may say, in so many words.
Great. Thanks very much.
If I
Would it
could
do with the next case in just a few minutes so that Vanessa could
Sure.
talk about dodging as well? Yeah.
The next case is Safina, where there is a sale of shares, in this case, by the Belgium company of shares held in a Singapore company. And the same proposition was sought to be applied. The provisions of Article 13.5 of the India-Belgium Treaty were almost pari materia with Article 14.5 of the India-France Treaty. Here, the only other point that I seek to emphasize is the court also considered the connotation of the expression participation when it talked of participation of at least 10%. And the Indian revenue therefore sought to say that participation would imply that you have a right to participate in the profits of that enterprise, and therefore, because you have a right to participate in the profits of the Indian entity which was owned by the Singapore company, to that extent, there is a transfer of interest in the Indian company through the sale or acquisition of shares of the Singapore entity. Now, in that context, it was held that the reliance by the Indian revenue on the meaning of the expression participation, which was in a different context in Section 2, subsection 18, Section 222 or Section 232 of the Income Tax Act, was not appropriate to a situation envisaged in Article 13.5 of the India-Belgium Treaty, where it talked of participation or in the capital of the company to an extent exceeding 10%. And on that basis, it was ruled that you cannot read the provisions of the domestic legislation as part of the double tax treaty, the India-Belgium double tax treaty, to bring to tax capital gains arising on sale of the Singapore company to the Belgium enterprise, on the basis that it held substantial value in the shares of the underlying Indian company. So this was the proposition with respect to participation that was highlighted in the judgment of Safina. And again, the reliance on Article 3.2 was negative to come to the conclusion that capital gains are not liable to tax in India. So this was the other judgment in this context, where the retrospective amendment made by a subsequent Finance Act in the domestic legislation was held to be not applicable while interpreting the treaty.
Clear. Thanks very much, Ajay. Although there are themes to address on these, I think we need to go and hear from Vanessa first on the important theme of treaty dodging, and then after that we may revisit some of the other cases and take questions. So Vanessa, please, the floor is yours.
Yes, thank you. I will try to be brief. I know we don't have much time, but I wanted at least to bring some ideas on tax treaty dodging, which I also refer in my thesis as the improper use of tax treaties, not by taxpayers, but by contracting states, which was also the object of my PhD research. And it also has a link to the discussions we've been having here, at least to some cases. So to understand it, and also to understand this link, you need to zoom out a little bit from Article 3, Paragraph 2, and try to have a more general view of the ways in which, different ways, or even indirect ways in which contracting states may impact the application of treaties. So to make it easier, I always like to make a comparison or a parallel between tax avoidance and treaty dodging, because for me, they are equivalent methods, just done by different subjects and for different purposes. So if on one hand you have a taxpayer that tries to organize its business in a way that works through the loopholes of the law in order to get to pay less taxes, we may also have contracting states through domestic law or other actions trying to extend their taxing rights without breaching the word of the treaty, and then maybe alter the balance of the treaty. So to make it more concrete, if you have a taxpayer that may maneuver their transactions in a way to attribute income to a related party that is subject to less taxation, lower taxation, you may also have contracting states through domestic law trying to attribute income to a taxpayer that they are allowed to tax under the treaty. Or if you have a taxpayer that tries to choose certain legal forms for the transactions in order to characterize an income as a type that is subject to a lower taxation. You may also have contracting states, as we saw, using deeming provisions or redefinitions in order to recharacterize an income so that it would fall into the scope of another article that is more beneficial to that state. So the danger of treaty dodging really happens when we are in those areas where states have some leeway or a certain freedom to act, which I refer in my research as the treaty gaps, as opposed to the loopholes of the legislation when we're talking about tax avoidance. And these areas where states have some freedom to act, they not always only refer to redefinition of terms in Article 3, Paragraph 2. there are many other areas where states have some freedom to act and they may impact the treaty. So, for example, when states are determining the elements of the tax liability, so when states are drafting legislation that is necessary for them to charge a tax, and that is normally under the competence of states, not for treaties to do. So, for example, when their states are determining the taxable event or the taxable base or the tax to be charged, so there they may find opportunities to make use of this freedom to impact the treaty in a way to extend their taxing rights, for example, and therefore altering the balance of the treaty and going beyond the legitimate expectation of treaty partners, and eventually also being not in line with certain international rules. So this was not, however, what happened with Fowler. In the Fowler case we saw, because as we discussed here, the UK did not intend to draft a deeming provision in order to impact the treaty and extend its taxing rights. Actually, it was the opposite. The effect of the deeming provision in Fowler was that the UK would lose its taxing rights. So there we cannot talk about treaty dodging in that. But you could argue treaty dodging, for example, in the Dutch case, where you could say that maybe the Netherlands tried to, let's say, shift from one article which was not as beneficial, so a dividends article or capital gains, into an article that granted more taxing rights, and doing that through redefinitions or deeming provisions. The shifting from one article to another that is more beneficial to the state is not the only way where states can try to take advantage of the treaty. They can also impact the treaty in a way to prevent the application of the treaty as a whole, so that they are allowed to apply their domestic law. So what I did in my research was I tried to identify the cases where I saw this pattern, and I tried to categorize them into the different types and methods of treaty dodging. And one of the methods is related to the one we've been discussing here, is a method through the redefinition of terms that are not defined in the treaty. So you can impact the treaty through that method. But there is another method also that I've been discussing a lot lately, which is the dodging through the determination of the tax liability, or the elements of the tax liability, as I said. And as an example, you may have states that try to redesign taxes in a way that they would fall outside the scope of treaties, and then they don't have any more delimitation of the treaty. That happened, for example, at least from my view, it happened with Brazil, when Brazil some time ago tried to convert part of an income tax that was levied on royalties into a contribution that was escaping the scope of the treaty. So back then, Brazil used to charge 25% withholding tax on royalties, and this rate was lowered to 15% in most cases because of the treaty. And then it decided to draft a legislation to reduce the rate from 25 to 15, and transform this 10% into a contribution that would fall outside the scope of treaty. So in the end, Brazil was continued to charge 25%. It dodged, let's say, the limitation of the treaty. And this redesign of taxes is also something that is being discussed nowadays, because in the context of the digital economy, because of some of the digital taxes. I know that in India you also have this discussion in respect of the equalization levy, which probably you know better than I do. But that's also one method. Under this method of the elements of the tax liability, you may have states, for example, playing also with the taxable events of the tax. So they may consider the taxable event to occur at a moment where they can still tax that taxpayer under the treaty. So that happens sometimes in certain cases of exit taxes. And another method that I also came across was what I call the legislature omission. And that's when the states, they do not take all the necessary steps to properly implement a treaty or a provision. This is very much referred to in literature as treaty underwrite. I think Richard Van was the one who mentioned that first time. And there you may see, for example, even clauses like a mutual agreement procedure that would need certain implementation at the level of the state. And if the state does not do that, you are kind of removing the effect of that provision. Some states may also do this method through by not, let's say, ratifying treaties or postponing or delaying the ratification of treaties. And that happened, for example, with Finland and Portugal. I think last year or 2 years ago, Finland terminated a treaty with Portugal because of that. They had a treaty, a very old treaty from the 70s that was in force. And they decided to sign a new treaty, and they did that in 2016. Finland ratified the treaty, but Portugal didn't. And considering the facts and circumstances, you could tell that Portugal didn't do that because it was benefiting from the first treaty, for the older treaty, because of a pension income article, and they were attracting pensioners, Finnish pensioners. So what Portugal did was Portugal did not ratify the new treaty because it wanted to keep the first treaty in force. And at a certain point, Finland protested, made an official complaint about that, and ended up terminating the old treaty, like the first treaty. So now they don't have a treaty in force because the first one was terminated and the new one is not yet ratified by Portugal. So that's also a way that you can try to prevent the application of a treaty. And well, I also realized that the method was also not only done through domestic law, like actions or omissions of domestic law, but also through some executive acts. So that's what I call the executive dodging. So some acts like instructions and interpretative acts that end up impacting the treaty also to extend the taxing rights of the contracting states. And what I've, to conclude a little bit, what I did in my research is because if you look at tax avoidance and treaty dodging, although they are comparable, they require a completely different analysis because under treaty dodging, we are between states. So there is a dynamic between states and relationship between states. So you need to take a lot from public international law. And of course, there are many rules that we already know, like Article 31, rules of interpretation of the Vienna Convention, and good faith is a very important element for that, object and purpose as well. But I also realized that there are other rules under public international law that can be used for and that should be considered when you are assessing treaty dodging. For example, Article 18 of the Vienna Convention brings the obligation for states not to defeat the object and purpose of a treaty prior to the entry into force of the treaty. So you could use that, for example, to condemn the actions of states that are not taking all the necessary steps to implement a treaty. You may find also other rules and sources in international law where states can, let's say, grant some guarantees and make some commitments, like in bilateral investment agreements, or even some human rights conventions where you can grant certain rights to taxpayers, and they could use that if they have been affected by treaty dodging. There are also other measures in international law that were interesting to see, not only, for example, an official protest from the other country may protest and issue an official protest against the dodging action, but they can also use countermeasures, or even they can claim state responsibility for international wrongful acts. And by doing that, they can claim cessation of the act, so they can demand that the dodging stops, or they can even claim compensation, for example. So there's a lot under public international law that you can take from, and I tried with my research to, let's say, help a little bit with that, bringing all the rules and possibilities for the proper assessment of treaty dodging. So I hope I was quick enough.
Yes. No, thanks, Vanessa, for this nice and interesting excursion, really. Slight diversion from Article 3.2, although part of this is in the Article 3.2 space, of course. It triggered some questions from the audience, I see as well. So maybe this is a good point to turn to some of the questions from the audience. Dhruv raised attention with me to a question that dealt with 3.2 and competent authority, I think, MAP. Yes. So Dhruv, could you please introduce that question and respond to it as well?
Sure. Rajat Bansal has raised a very interesting question right at the beginning of this presentation, where he asks, if domestic law defines a term, the occasion for competent authorities agreeing to an interpretation under 25.3 should not arise. If it has, why should this 25.3 interpretation override domestic law meaning? Isn't the 2017 insertion self-contradictory? I do not know if it's necessarily self-contradictory, because I actually don't think it changes anything, because the only manner in which competent authorities can come to a decision under 25.3 if there is a difficulty of interpretation or application. So that is a threshold one needs to overcome before one applies Article 25.3 at all. And that's the only scenario in which the authorities of contracting states are competent to even start an interpretative mutual agreement. The only other situation in which they may do it is if there is unrelieved double taxation. That's the second sentence of Article 25. It's important to make a distinction over here that 25.3 does not refer to double non-taxation as a ground for entering into a mutual agreement. You get into an interpretative mutual agreement only in case of double taxation, which is also the reason why the Dutch Supreme Court, the German Supreme Court, and the Belgian Supreme Court have all struck down mutual agreement procedures, competent authority agreements, which sought to avoid double non-taxation. So that's an interesting one. How far does 25.3 actually allow authorities to be competent in concluding a mutual agreement? I think it might just, the purpose of including reference to 25.3 in Article 3.2 is simply to make competent authorities aware that, hey, you do have the power to conclude suo motu, if I can use Latin, where you can take cognizance of a difficulty by yourself. You don't need to wait for a taxpayer to raise an issue. If there is a difficulty of interpretation or application, get on with a mutual agreement and you can resolve it. You don't necessarily, in that case, have to rely on domestic law. But what exactly are these difficulties of interpretation and application? That is the key question that would still remain to be answered, and that threshold will have to be met before you can deviate from the domestic not definition, but rather the domestic meaning of a term. So that would be my response to Rajat's question.
Dhruv, I would also like to express some observations, and I very much follow your remarks and the question as well. So first of all, in line with this Dutch Supreme Court case, any difficulties or doubts? In that particular case that I was referring to, the court had, previous to the case that dealt with the competent authority agreement, the court had, in a judgment, given its interpretation of a particular treaty term. So the court basically said Article 25.3 does not leave the competent authority any room to address the interpretation because there is no difficulty or doubt anymore. And if the competent authority then decides anyway on a different meaning, the position would be that if that is sufficiently known to the taxpayer can rely on that if it would be more favorable, but it could not be used against the taxpayer. Now, let's assume that the court would not have ruled on an interpretation, that the competent authorities have convened and decided on an interpretation because there was doubt or difficulty or doubt, but then subsequently the court does interpret the term. Does that then overrule the competent authority agreement at that point in time because the difficulty and the doubt have been resolved? And if you overcome that and assume for a moment that the competent authorities can make this agreement under 25(3), assume also that this has been published adequately so that everyone knows about it, what then does the addition to Article 3, Paragraph 2 add to that? And in my mind, it could add something in the sense that Article 3.2 is not only addressed to the government and taxpayers, but is a rule that the court has to apply when it interprets the treaty. And that's where I start to feel highly, at least somewhat, but potentially highly uncomfortable, because have we given the competent authorities powers here that are no longer controlled by the Constitution? Because an amendment of a treaty term clearly needs, the approval as required by the Constitution of the contracting states. So if you start to tinker with the meaning of terms, and then through Article 3, Paragraph 2, make that a binding interpretation rule, if that's the case, then I guess the democratic process of approval of tax treaties is potentially pushed aside. So I think 3.2 in combination with 25.3 is really problematic. And we have yet to see where the boundaries of these provisions are, I think.
Steph, if I can come in, I would say that does it take away the jurisdiction of the court, notwithstanding an agreement between the competent authorities? Can the court still step in and, interpret the particular amendment in the domestic legislation and hold that whether having regard to Article 3.2, that can be read as part of the treaty? I would think that the agreement between the competent authorities may have persuasive value for the court, but the court can independently come to a different view. That's my understanding.
Yeah, that is a very balanced approach.
Yeah. If Steph, I could tie. You've raised a number of very fascinating questions, and I don't think I can, I don't think this panel could imagine answering all of them right now. But there was one question that Mukesh raised at the very head of this session whilst introducing it. And he said, why did Dhruv insist on domestic law meanings rather than domestic definitions? Yeah, and that's basically where one comes into this idea of, first of all, there are undefined treaty terms that are different from the word. So, for example, to take a segue from what Ajay was saying, the term alienation the word alienation has not been used in Indian domestic law, but at the same point of time, the term transfer has been used. Now, I think the domestic law meaning of a term, alienation, can be equated with transfer. And I don't think you need to have exactly the same word in domestic law and in the treaty for you to have reference to domestic law. That's number one. Number two, a term need not be defined under domestic law in the black letter of the law, but you can have a domestic law meaning, which can be derived from case law, from custom, protocol, whatever. And so I think the domestic law meaning is a much broader term than just a domestic law definition. And also the term is a broader term than the term word. And therefore, I basically talked about it. Coming to the very question of what is it that the court does, I think what a court does in interpreting the law is quite often is revealing what the domestic law meaning of a given provision is. And if according to the court there is a clear definable meaning of a term, I don't think it would be bound by the competent authority agreement, even in that in the case of the 2017 reference in Article 3.2 to competent authorities. That would be my take on the issue.
It must be the right answer, but let's see how this plays out in court. I realize we still have a few unanswered questions that deal mostly, I think, the uncovered ones with treaty dodging, but we are 11 past the hour, so with apologies to the persons who raised those questions, I'm inclined to turn over to Mukesh again, but not after having thanked my co-panelists. I truly enjoyed, I'll speak for myself, our panel here, and thank the audience for being patient and stay with us. So thanks very much. And with that, I turn it over to Mukesh again.
Thank you, Steph. It is not easy for anyone to be able to summarize this, and I'm not even going to attempt to do that. But I just thought I will take one more question that has come in, and whoever wants to answer that. It's a very interesting question. It says, can a generic provision in a domestic law, such as requirement to get a tax residency certificate, be considered as a unilateral move? And this question is very specific to India. So let's assume that in the domestic law, there is a requirement for tax residency certificate. And the question is, would denying benefit in such circumstances is valid, especially on the meaning of the definition of Article 3.2? So whoever wants to take that question.
I think this is straight in Vanessa's court. But if Vanessa is done, I have a thought as well. But Vanessa, would you venture for this one?
Yes. Well, for me, from what I see in other cases, that I also saw some executive acts that would try to put some obstacles to taxpayers' rights. And it depends. I don't know how it is in India, but if this requirement is imposed in a way that would prevent them to exercise their right of being a tax resident for the purpose of the treaty, I would be inclined to say that it could be seen as a treaty dodging. But I think it depends also on which type of form and what are the requirements that they make for that.
Yeah, and I think I just was looking, and I did not see it in Articles 11 and 12. Yes, I do. So, for instance, Article 11, paragraph 2, second sentence says, the competent authorities of the contracting states shall by mutual agreement settle the mode of application of this limitation. And you find comparable rules in 10 and 12. That, of course, deals with the administrative rules to implement the treaty rule, and that is only, normal and understandable. But if we get to a point where a country sets conditions that are inconsistent with the treaty rules, then it becomes problematic, of course. And I would think it's interesting in the Dutch context, and I apologize to come back to the Dutch context many times, but we have rules for determination of treaty residence in other countries, and basically we can rely on the determination by the other countries' tax authorities. with two exceptions. One is the taxpayer has provided the tax administration of the other country with inaccurate information, so that its decision was based on the wrong information. Or the second exception, the determination by the foreign tax authority cannot reasonably be based on any interpretation of the foreign tax law on residence. And I could see that a requirement for tax residence of a residency certificate, I should say, in line with the question, if that would become unreasonable given the application of the law, then you just ignore it and you allow the taxpayer the treaty relief if the taxpayer would otherwise have demonstrated that the treaty conditions have been met.
Thank you. Maybe we can seek indulgence on one more very interesting question. There is a decision of the Mumbai Tribunal in a case where the tribunal has held that Article 3.2 covers only royalty. However, it would not apply to process, which is a subpart of the term. Would anyone like to take a stab at this question as well? Perhaps Ajay or Dhruv?
Yeah, Mukesh, as I mentioned in my remarks, I would tend to take the view that the term royalty is already defined under the treaty. And you cannot possibly rely on Article 3.2 to say that the enlarged definition of royalty in terms of explanation 4, 5, and 6, which are deeming provisions, should be treated as part of the treaty definition of royalty, because the term royalty is specifically defined in the treaty. Second, the term process is a subpart of the definition of the term royalty, where it refers to and therefore, it says, the treaty says the term royalty means so and so, and the term royalty is defined. We are not looking at definition of subterms, and the word process is a term of English language, as people understand. It doesn't have to be defined in the Act. Merely because we've introduced a deeming fiction in explanation 4 cannot ipso facto automatically be treated as part of the royalty definition for purposes of the treaty. And I think the tribunal has, to my mind, taken the correct view.
Thank you, Ajay. Well, I mean, much as we would have liked to carry on with this interesting conversation, which is so enriching, but we've kind of exceeded it and we'll have to close the event. Thank you very much for your participation.